Hello, Prof. Am I audible?
Can you hear me?
Yeah, we can hear you very clearly.
Okay, good.
Okay,
So
so as for now, yeah,
this is
sorry.
the first time. I mean, StreamMax is the first time. So can I do the
Uh,
background? Change the background. How to change the background? This is my
uh, to,
hope.
to change the background, you need to click on the setting, the gear icon, and then there is an option, virtual background, the fourth option.
Sorry,
You can change.
go to which one?
You
My
can go to
microphone.
the setting, the gear
Setting.
icon,
Okay, setting. Okay,
and then there is an option,
virtual background. Okay, virtual
virtual
background.
background, and
Okay,
then you can click on the virtual background on the plus icon.
okay,
So it might take some time to loading. Yeah,
okay.
after you click it. So we are still waiting for the participant. So currently we wait maybe around 2 or 3 minutes, and after that we can proceed with our forum.
Okay.
Apart from that, we are there is for some circumstances that we are currently only have one panelist because unfortunately Dr. Sabras cannot attend for today. There is some issue regarding that. So maybe we can shorten the length of this forum. We will look into the suitable, but basically the topic is still the same. Just only the moderator and the panelists lah yang will be going to
Okay. So
handle this.
we have two
Okay.
panelists, right?
Yeah, supposedly we have two panelists, but unfortunately, due to some circumstances, Dr. Sabresh will not able to attend. So
Oh, okay.
just
Only
only
one
me
panelist
and
only. Me
yeah,
only. Oh,
mm-hmm.
okay.
Only. So, but I will try to get more engagement with you in this so-called forum to make it not like a kind of one-way discussion. So we have everything went smoothly.
Okay. No problem.
We,
No problem.
so we will start officially on 10:20. Is it okay?
Okay, no problem.
Okay. Assalamualaikum and good morning, everyone. Welcome to ILSA UniSZA Forum Series, the first 2023. On the South China dispute from the perspective of international law. I am your moderator today, Farisang Rahman, and I am honored to be your moderator for today's discussion. We have a very distinguished panelist with us today who will share his insight on this important topic. Our panelist for today is none other than Professor Dr. Abdul Ghafur Hamid. He is renowned expert in international law of the sea, maritime law, and international trade law with over 40 years of teaching and research experience. Prof. Ghafur has authored or edited over 17 books and published numerous articles in international and referred journals. Prof. Ghafur is currently a professor of law and coordinator of the International Law and Maritime Affairs, ILMA, research unit of the IIUM. He also completed his research project on the project Marine Environment in Malaysia, and his ongoing research project is focused on formulating the legal framework for sustaining maritime security in Malaysia. Prof. Ghafur is a member of the Maritime Institute of Malaysia, MIMA, and a member of Asian Society of International Law, and he also served as editorial board member of the Journal of East Asia and International Law, and he is the editor of the IIUM Law Journal. We are truly honored to have Prof. Ghafur as our panelist today, and we look forward to hearing his insight on the topic South China dispute from the perspective of the international law. Prof, can you briefly introduce yourself so audience can know you better?
Okay, thank you very much. Bismillahirrahmanirrahim. Alhamdulillah Rabbil Alameen. Assalamualaikum warahmatullahi wabarakatuh. And very good mornings. So I think the Mr. Faris, the moderator, has already been introduced me. I think I'm not necessary to introduce myself. So I'm Professor Abdul Ghafur Hamid, a professor of international law from Ahmed Ibrahim Kuliah of Laws, International Islamic University, Malaysia. So I'm very happy to be a panelist in this forum on South China Sea from international law perspective. Thank you very much, Mr. Faris.
Thank you so much, Professor. Now we have our panelists ready for this topic. Let's dive into the discussion. However, before we proceed, let's watch the video on today's topic that have been prepared by our media team.
The South China Sea dispute involves multiple countries, including China, Vietnam, Philippines, Malaysia, Brunei, and Taiwan. It is a complex territorial and maritime dispute over the sovereignty of islands, rocks, and reefs, as well as the delimitation of maritime boundaries and the rights to natural resources in the South China Sea. This dispute has significant strategic importance due to its rich fishery resources, potential oil and gas reserves, and its location as a major shipping route. International law plays a crucial role in the South China Sea dispute, particularly through the United Nations Convention on the Law of the Sea, UNCLOS, a treaty that sets out the legal framework for the use and conservation of the world's oceans. Legal principles applicable to the dispute include territorial sovereignty, maritime entitlements, freedom of navigation, and dispute resolution mechanisms. One significant legal development in the dispute was the ruling of the Arbitral Tribunal in the Philippines versus China case in 2016. The tribunal declared that China's claims in the South China Sea based on historic rights were inconsistent with UNCLOS. However, China has asserted that it has historical rights and claims in the South China Sea based on its 9-line map, which covers a large portion of the sea. China has rejected the Arbitral Tribunal's ruling and argued that the dispute should be resolved through direct negotiations with relevant parties rather than international legal mechanisms. China has also expressed concerns about the intervention of external parties and emphasized its commitment to safeguarding its sovereignty and security interests in the South China Sea. The dispute involves various perspectives from claimant states and non-claimant states. Claimant states such as China, Vietnam, Philippines, Malaysia, Brunei, and Taiwan have varying degrees of territorial and maritime claims in the South China Sea, each with their respective interests and concerns. Non-claimant states, including the United States, Japan, Australia, and ASEAN countries, have expressed concerns about the impact of the dispute on regional stability, freedom of navigation, and adherence to international law. The international community also has concerns about the escalation of tensions in the South China Sea and calls for peaceful resolution through diplomatic means. Efforts to promote dialogue and cooperation among parties are seen as crucial in addressing the dispute. However, there are challenges to the application of international law in the South China Sea dispute, including differing interpretations of UNCLOS, lack of enforcementisms, and complex historical and geopolitical factors. The impacts of the dispute on regional stability, security, and economic interests are significant, including increased military presence, heightened tensions, potential for conflicts, and disruption of trade and economic activities in the South China Sea region. The implications for international relations and the future of the South China Sea are important. Peaceful resolution through diplomatic means, multilateral efforts to uphold international law, and the importance of cooperation and dialogue among parties are crucial for regional stability and security. In conclusion, the South China Sea dispute is complex with significant legal, geopolitical, and economic implications. International law, particularly UNCLOS, provides a framework for addressing the dispute, but challenges remain. Join us for the ILSA UniSZA Forum, Series January 2023 on April 15, 2023, for more insights on this issue from international law perspectives. The forum will be live on ILSA UniSZA Facebook and YouTube. Don't miss this opportunity to deepen your understanding of the South China Sea dispute.
Okay, there you have it. A video prepared by our media team. So the reason why we prepare the video so that the audience have the context about what the topics is all about. So at least you have a brief introduction in before we go in depth into the international law realm. So before we begin, let me provide some context for our discussion. We will separate it into several topics. The first, the South China dispute have been continuous issues many years, involving countries with competing claims in the region. As a forum, we aim to examine this issue with various angles, like legal framework, historical claim, maritime security, and the potential solution. So the first one is we're going to touch on the background itself, the background of this issue. Throughout this forum, we also hope to foster constructive, informative discussion on the South China Sea dispute, exploring the complexities and challenges from the international perspective. We will dividing our discussion with different sections, as I mentioned earlier. The next would be on the legal framework perspective, followed up by the historical claim and legal claim. After that, we are going to look into the maritime security and freedom of navigation. We will continue with regional and global impact, but we also include the Malaysian role as in this topic. So Malaysia and South China is also part of this discussion. And the last would be the potential solution. So without wasting much time, I think we can start our today first discussion. So, Professor, we are moving to the first section, which is under the topic of background context, where we explore the background in it. So, as for the first question, I think it would be great if we want to know about your personal opinion regarding this issue.
Okay, so Mr. Ferris again.
Okay, sorry. I think
You are talking about the legal background, right? Legal background or what?
no. The the whole dispute background. Just a little bit. We want to know
Okay,
about your opinion
okay,
in
okay.
this
Thank you.
topic.
Thank you very much. Okay. Mr. Ferris, thank you for the question. So, Bismillahirrahmanirrahim. So actually, we want to talk about international law of the sea. So before starting this, the background of the South China Sea dispute, so the background of the international law of the sea itself. So the very first, the most secret, and the very first principle, fundamental principle of international law of the sea is what we call freedom of the sea, the doctrine of freedom of the seas. So it was actually propounded by the Dutch jurist Hugo Grotius on the basis of his book, Mary Liberum. So freedom of the seas. The seas are free. The seas are free here means no states can claim sovereignty over the seas. No state can occupy the seas. Okay, seas are for all. So for all states, for all people. So this is the very first fundamental concept of the law of the sea. But in the 18th century, so some states, they want to have to exercise some measure of sovereignty or sovereign power on the sea, which is very close to their coastline. Their coastline. So then this is called the territorial sea, or in the past we call territorial waters. Then states are claiming that they should have sovereignty over certain areas of it, which is close to their mainland or islands. So this concept is the doctrine of the territorial sea. The territorial sea. In the past, it was claimed as 3 nautical miles, and now in modern time, 12 nautical miles. So this is the second concept of the law of the sea. Okay? Law of the sea. So that's why from that, the first maritime entitlement, this is the first maritime entitlement. Previously, only freedom of the seas, only the seas are free for all states. But now, states are claiming the first maritime entitlement we call territorial sea, over which a state can claim sovereignty. So this is the first maritime entitlement, which is also based on the coastline or the land, the mainland. So that is why from that, the early development of the international law of the sea, so very important principle has emerged. So that principle is known as the principle that the land dominates the sea. The land dominates the sea. I will discuss later on when we discuss about the South China Sea dispute, the basic principle we have to apply. Okay, now in the 20th century, so there are extended claims made by states over the seas. Extended claim made by states. Even territorial sea has been extended from 3 miles to 12 nautical miles. And not only territorial sea, there are other maritime entitlements claimed by states. For example, contiguous zone up to 24 nautical miles from baseline, and then EEZ, exclusive economic zone, 200 nautical miles from the baseline, from the coast, and then continental shelf, the seabed and subsoil, the natural resources of the seabed and subsoil, which can be up to minimum 200 nautical miles, up to maximum 350 nautical miles, or even more. So there are 4 maritime entitlements: territorial sea, contiguous zone, exclusive economic zone, and continental shelf. And because of these extended claims over the seas, more disputes on maritime claims can be found, especially in the 21st century. However, the most comprehensive and highly contested maritime claims are those in the South China Sea. So if we can divide these maritime territorial claims in the South China Sea into two main disputes. The first one is the 9-dash claim of China, based on the 9-dash line claim of China, which encompasses more than 90% of the South China Sea and overlaps with exclusive economic zone claims of Taiwan, Vietnam, Indonesia, Malaysia, Brunei, and the Philippines. This is the first main dispute. The second main dispute is the claim of sovereignty over various maritime features in the South China Sea. including the Spratleys Islands, Paracel Islands, and Paratas Islands between China, Taiwan, Vietnam, Malaysia, and the Philippines. So this is an ongoing and long-time dispute, and it's also a bit complex and complicated dispute. And there is only one, attempt to decide it by the third-party decision making. That is, as you all know, the South China Sea Arbitral Tribunal decision. South China Sea Arbitral Tribunal decision, which is between the Philippines and China. But unfortunately, as you all know, so China did not recognize the tribunal, did not accept the jurisdiction of the tribunal, and also totally rejected the award of the tribunal. So that's why the South China Sea dispute is still ongoing, and there are so many issues, so many issues of building the artificial islands, and then the upgrading and developing small coral reefs and atolls to become islands, so that states can have more maritime entitlement from these so-called islands. So that is why this is, I think, the most comprehensive and highly contested maritime claims ever in the entire international community. So this is just the background beginning of the SCS dispute. Thank you very much.
Thank you, Prof. I think that's a very complete introduction over the topics, and also a little bit about the UNCLOS and about law of the sea itself. So I think it is important for audience for us to discuss about the reason behind why China, not only China, I mean like almost every nation, every state in Islam, think that this region is very important, the South China Sea is very important. So can you explain what are the reasons why China really wanted this so-called their historical right region, the South China Sea? What are in there?
Okay, so not only China, all states are there. The region, the South China Sea is at stake for China as well as all the six countries involved here in the disputes, right? So why? Because there are so many reasons, so many grounds. The first thing is the natural resources. So China is very rich in natural resources. The first thing is, as you all know, oil and gas, minerals. That is especially in the seabed and subsoil. Yeah? The seabed and subsoil of the South China Sea very rich, and you can drill oil, natural gas, and so many other types of minerals. This is the first thing. And also, when we talk about natural resources, the living resources, not only non-living resources, but also living resources, fishing, especially fishing, very rich in fish, so many types of fish. So this is for economic purpose. For economic purpose, the economic ground is there. South China is very, very important for economic ground because of the richness of natural resources. And the second one is for transportation. So for China, especially for China, the oil from the Middle East, China is now, I think, economically very, very powerful, and industrially also now well developed. So they need a lot of oil. So to get this oil, they have to bring this oil from the Middle East, pass through the Strait of Malacca, and pass through the South China Sea to China. So that's why this South China Sea is for transportation purposes, for flow of goods, carriage of the important oil and natural gas. For transportation purposes, this is very important. And for security purpose, from security point of view also, this is very important because it is affecting the main area, China, Taiwan, and then all the ASEAN countries. Most of the ASEAN countries are involved there, except Myanmar. So and the landlocked countries like Laos and Cambodia, We have Vietnam, Thailand, Malaysia, Indonesia, Singapore, Brunei, Philippines, all these around 8 ASEAN countries are also involved. So this China, South China Sea is not only, it is also circular way of sea, so semi-enclosed way of sea. So that's for security purpose, affecting all these countries is very important. So that's why if some state is doing these military bases, establishing military bases in the South China Sea, others say that this is a very sensitive matter. Now China is doing some military recruitments and military developments on some of the islands and atolls in the South China Sea. So these are the main reasons that why the South China Sea is so important, not only for China, for all the relevant participants in the disputes. Thank you very much.
Thank you so much, Prof. So I think let's cover all the questions. So I have another question regarding the whole so-called China claim. So this is regarding the 9-line. So the thing is about 9-line. Why is that is the region? Why China claim only that part and not go beyond or go before the 9-line? So what are the reason and what is uh, China reason to claim that is their territory?
Okay, so this is the first main issue, first main dispute between China and other other states, other disputing states. So 9-line claim. So this is on the basis of the Chinese claim. This is based on their long time historic title, historic rights over the sea, because the Chinese naval admirals and naval ships pass through the South China Sea, and they are going around and they are conducting and regulating the South China Sea for so many years since 17th, 18th century. So based on that, China claimed that they have historic rights on South China Sea, because otherwise, so they cannot claim on the basis of the ordinary principle of international law or UNCLOS provisions. Because according to UNCLOS provisions, it must be based on as I told you before, the main principle is the land dominates the sea. So the land dominates the sea means it must come from the coastline, the mainland of China. Because the islands in the areas are disputing islands, right? Nobody can definitely say that who owned the island or who can definitely exercise sovereignty over these islands. And some are not even islands. They are atolls, atolls, and they are coral reefs. Most of them are uninhabitable. Okay? Uninhabitable. So that's why from these small atolls or coral reefs or some are even low tide elevations, it's below sea waters. So you cannot claim from the ordinary basic principle of international law, that is the land dominates the sea, it must come from especially the mainland or the full-fledged island. It must be an island, not a low tide elevation or not just ordinary atoll or the what you call artificial islands. We cannot claim any maritime entitlements. So because of that, they are claiming on the basis of historic rights. They have historic rights over the seas, and this is when this claim start. They use the map for so many years, but the official position of the Chinese government based on this 9-line map was because of in that situation, Malaysia was involved, right? So that we have Malaysia and Vietnam jointly submitted on 6 May 2009 their claim on the EEZ, exclusive economic zone beyond 200 nautical miles. So if normally EEZ up to 200 nautical miles is already allowed by the UNCLOS. we can claim up to 200 nautical miles exclusive economic zone. But if it is more than 200 nautical miles, we want to claim beyond 200 nautical miles, okay, the continental shelf, the EEZ ends in 2000 nautical miles, and continental shelf is, the minimum is 200 nautical miles. And a state can claim continental shelf from this 200 nautical miles beyond. So it means that EEZ ends 200 nautical miles, but continental shelf will not end at 200 nautical miles point. It can go beyond 200 nautical miles if the states can show that it's the natural prolongation of the land territory. It means that the prolongation of the land mass from the mainland goes smoothly, and the seawater is shallow, not very deep, until the deep seabed comes. That is, we call at the outer edge of the continental margin. If the outer edge of the continental margin, that is before the deep seabed, before the sea seabed, that is the natural continental shelf of a state. So now Malaysia and Vietnam is claiming that our seawater is a bit shallow. That's why our continental shelf will go beyond this easy limit, 200 nautical miles. It goes beyond 200 nautical miles. If we want to claim beyond 200 nautical miles, then UNCLOS requires Article 76, paragraph 8 of the UNCLOS requires that these states must submit their case to the Commission on the Limits of the Continental Shelf, CLCS, Commission on the Limits of the Continental Shelf, which is established under UNCLOS. So now when Malaysia and Vietnam claim this continental shelf, which is beyond easy 200 nautical miles, immediately China respond and object to them. And China sent a note verbatim to the UN Secretary General attaching a map depicting the 9-dash line. As you all know, in the internet, you can see this map based on 9-dash line. So a map depicting the 9-dash line stating that China has indisputable sovereignty over the islands in the South China Sea and the adjacent waters, and enjoys sovereign rights and jurisdiction over the relevant waters, as well as the seabed and subsoil thereof. So this is the first time China officially claim and submit to an international organization, that's the United Nations, that they can enjoy sovereign rights over the sea area, South China Sea area, which is within this 9-dash line. This is the beginning of the 9-dash line claim. Okay, so now this 9-dash line claim is, even though in the China's notes verbatim, it says that successive Chinese government reaffirmed this 9-dash line claim, and it is in accordance with their domestic law, and also it is protected under international law, including UNCLOS. But when we really look at, but they didn't give any principle in international law which they can directly rely on. They didn't mention anything. Just very generally says that it is their 9-dash line claim is protected under international law, including UNCLOS. So that is why scholars and also later on at the South China Sea Arbitral Tribunal has to assume that it appears that China claims the South China Sea within the 9-dash line on the ground of historic rights. On the ground of historic rights, because nothing else, no principle has been expressly relied on by China. So that's why we assume that China claim, 9-dash line claim in the South China Sea is based on historic rights. So I have to go on these historic rights, or do you have any questions on historic rights? Any more questions? Or I have to proceed?
I think it's interesting when you mention about his so-called historic right of China in the South China Sea. But I think we do have a separate topics on that. So I think we can proceed with more in depth into the legal framework. Let's look on the UNCLOS itself.
Okay.
So my question is, how does UNCLOS apply to the South China Sea dispute, and what are the key provisions that are relevant to the conflicting claims?
Okay, thank you very much for the question, Mr. Ferris. Okay, so this is, I have already started with the basic principle of this, the land dominates the sea. Now I will go beyond, I will go a bit more details. So two principles of the land dominates the sea, how it is applicable, whether it's established law, international or not, and whether it can be applied from the mainland only or can apply from the island only. So I will touch on the regime of islands under the UNCLOS. Okay. So now this, so as I told you before, the basic principle of international law of the sea on maritime entitlements, territorial sea, contiguous zone, exclusive economic zone, continental shelf is the principle of the land dominates the sea. So why this is so? Why land is the basis for any claim for maritime entitlements? So by nature, the land is concrete, solid, and susceptible to physical occupation. We can physically occupy a land. How can we physically occupy the sea? The sea is fluid. And for example, airspace also, airspace. Airspace is invisible and untouchable air. So how can we physically occupy? That's why the main physical occupation for the exercise of sovereignty of a state is only the land only. From the land, the others are extension from the land. So that's why the land must be always the origin of the sovereignty, claim of sovereignty. So that's why according to the principle that the land dominates the sea, the land is always the basis for any claim of maritime entitlements. Without a land with a coastline or coastal front under its sovereignty, no state can claim any maritime entitlement. And this is an established principle of customary international law developed through state practice and judicial decisions. So there are many international court of justice decisions, successive decisions, reaffirm again and again the principle of the land dominates the sea. For example, in the very early case is the Anglo-Norwegian fisheries case, 1951. So the ICJ decided that it is the land which confers upon the coastal state a right to the waters of its coast. And in 1969, very famous North Sea Continental Shelf cases, the ICJ decided that the land is the legal source of the power which a state may exercise over territorial extensions to seaward. And then this influence of this principle can also be applied in the doctrine of continental shelf, because continental shelf is also founded on the natural prolongation of land territory. So the natural prolongation land territory is go beyond, below the seawaters, the seabed and subsoil. The seabed and subsoil is the natural prolongation of the land territory. That's why all the maritime entitlements are to be based on, to derive from the sovereignty over the land. So this is the judicial decisions, all accept that, state practice accept that. And then let us look at the application of this principle to islands. It is not applicable to mainland only. It is applicable to islands as well. That is a very famous case, Qatar in Bahrain case, 2001. The ICJ decided that this maritime rights derived from the coastal state sovereignty over the land. This principle of the land dominates the sea has been decided so many times, reaffirmed again by ICJ. But this is not only for the mainland. It also extends to islands. Islands, regardless of their size, enjoy the same status and therefore generate the same maritime rights as the mainland territory. So that's why this principle can be applied not only for mainland, but also for islands, regardless of their size. Now let us look at the UNCLOS. The land dominates the sea is enshrined in UNCLOS 1982, Article 2. In Article 2, Clause 1, the sovereignty of the coastal state extends beyond its land territory. So that's why it comes from the land territory. It originated from land territory. Sovereignty of a coastal state extends beyond its land territory to an adjacent belt of sea. Adjacent means close by, close to the land. Adjacent belt of sea known as territorial sea. So that's why the sovereignty comes from the land and it extends to the territorial sea. And also it extends to the airspace over the sea, and it extends to the seabed and subsoil, which is below the sea waters. So this extension of the sovereignty is originated from the land territory. Okay, so this is Article 2 of the UNCLOS. And also we have the baseline systems. When we talk about maritime entitlements, territorial sea, contiguous zone, EEZ, continental shelf, all the maritime zones are to be measured from the baselines, the baseline systems under the UNCLOS, starting from Articles 3, 5, 7, 33, 57, 76. All the maritime zones are to be measured from the baseline. But what is the baseline? Baseline is the normal baseline. Normally, baseline is the low water line along the coast. Low water line along the coast. So it is the low water line at the time of low tide, the line along the coast at the time of low tide. This is from coast. From the coast and from the land territory, you have to measure the maritime zones. From the baseline is from the land. It has to be measured 12 nautical miles, starting to sea, up to 24 miles, contiguous zone up to 200 miles, easy, something like that. Okay, so that's why only coastal state here means the state with a sea coast can claim maritime entitlements. Landlocked states like Laos, for example, like Nepal, for example, they cannot claim maritime entitlements because they have no sea coast. Only states with sea coast, mean coastal state only, they can claim maritime entitlements. And as far as the islands are concerned, we have Article 121 of the UNCLOS, the regime of islands. So this principle of the land of the sea also extend to not only mainland, but also islands. Okay, so now, as far as the islands are concerned, for example, I will just touch a little bit only on islands. Article 121, the regime of islands. This regime of islands, Article 121, is a manifestation of the principle that the land dominates the sea. There are 3 paragraphs. Article 121, 1. What is an island? So Article 121, 1 is the definition of an island. An island is a naturally formed area of land surrounded by water, which is above water at high tide. So based on this definition of island, so there are 3 elements to be an island. The first and the most important element is it must be a naturally formed area of land. Naturally formed area of land. So it means that it must not be artificial. It must be naturally formed area of land. Number 2, second element, it must be surrounded by water at all time, and which is above water at high tide. At the time of high tide also, it must be above water, always permanently above water. So naturally formed area of land, surrounded by water, and it must be above water at high tide. So that is why artificial islands are excluded, and then man-made islands are excluded. The extension of an ordinary natural island by means of this concrete and landfill or concretes or these reclamation of land, this is not natural. This is artificial only. And also, it must be always above water means low tide elevations. Low tide elevations are not islands. That's when we specifically look at many of the maritime features in the South China Sea. Most of them are low tide elevation. Low tide elevation means they are above seawater at low tide, but they are submerged or below seawater at high tide. So that's why low tide elevations are not island. They have no maritime entitlement at all. Now, Article 121, paragraph 2. These, if it fulfills the requirements of island, 3 elements of island, Article 121, clause 2 says that except clause 3, these islands have the territorial sea, the contiguous zone, the exclusive economic zone, and the continental shelf. Meaning that all the islands fulfill the definition of the elements of island under 1211, they are entitled to 4 maritime entitlements: territorial sea, contiguous zone, exclusive economic zone, and continental shelf. Then, what is the exception? Paragraph 3, Article 121, Clause 3 is an exception to that. So the exception says that rocks which cannot sustain human habitation or economic life of their own. Rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or no continental shelf. So rocks also may be islands, but here are certain types of rocks which cannot sustain human habitation. Human cannot, but the rocks are so solid that even we cannot drill water, we cannot have plantation, we cannot plant trees. So that's why it cannot sustain human habitation or cannot have economic life of their own. Not man-made created one, but their own economic life of their own. So these rocks, they have territorial, they can have territorial sea, they can have contiguous zone, but they cannot have the very important maritime entitlements, that is exclusive economic zone, no. Continental shelf, no. So this is the exception. So that's why when we talk about, when we have to consider what type of maritime features are entitled to as islands, what are not entitled as islands, and what are mere rocks which cannot sustain human habitation, economic life of their own. So this is the law. This is international law. This is UNCLOS to the mainland as well as islands, the regime of islands. So based on this law, so the arbitral tribunal has already been adopted a watch, and we have to also think about this, objectively on the basis of UNCLOS. Thank you very much.
Thank you so much, Professor. I think it's a very good insight. You have touched the limitation for the landlocked country and also the right for those coastal states. And I think there's a lot of provision under UNCLOS itself that mention that actually there is a lot of rights for the coastal state to enjoy, and they have a responsible to do so, to taking care of their territorial water. So my questions is, this is regarding China intervene in our so-called territory. So in UNCLOS itself, it says that we have the right up until 200 nautical mile, but clearly in the 9-dash, they ignore all of these territorial boundaries. So technically, is it possible for a country to do to act just like China did, or they are clearly violated the international law?
Okay, so you can just say again.
Okay, so currently that we have our own territory, and China now claim part of our territory sea. So is China really allowed to do that, or they are clearly violated the international law?
Okay. Now I got the point now, because you are talking about this legality, right?
Yeah.
Of 9-9 claim, right? Legality of 9-9 claims. So this is already also decided by the arbitral tribunal, but I will now I'm now giving my own views on this legality of the 9-9 claim. Okay, so actually this is what we'd call the claim of historic rights, whether they are claiming historic rights, it is affecting all the country, right? Malaysia, Brunei, Philippines, Vietnam, Taiwan, right? All the countries are affected because they have their own laws, exclusive economic zone laws, continental shelf acts. For Malaysia, Philippines also is affecting their exclusive economic zone. The 9-9 claim is clash with all these countries. At least exclusive economic zones are affected, and also badly affecting the continental shelves of all these countries. So that's why we have to see whether this 9-9 claim is allowed by international law or international law of the sea. That's why, since there is no other principle relied on by China, we assume that China is claiming on the basis of historic titles, or historic rights. So then, whether China can really claim historic titles or historic rights like this. So this juridical regime of historic waters or historic titles there was a study made by the United Nations Secretariat under the request of the International Law Commission in 1962. And there was a research done. They make a very comprehensive research on those who are claiming historic titles or historic title to historic waters. What are the required elements? So the research, the study found that, so there are 3 elements to be fulfilled. If a state want to acquire historic title to a maritime area, 3 elements need to be fulfilled. What is the first element? So the proof of the exercise of sovereign authority over the area by the claimant state. The proof of exercise of sovereign authority over the area by the claimant state. Proof of exercise of sovereignty. Number 2, this exercise of sovereignty must be in the continuous basis, continuously exercise of sovereign authority. If China claims that since 17th century, then it must be continuous, not only in 17th century. It must be 17, 18, 19, 20, and 20th century up to now. China has exercising sovereign activity continuously. Number 2 element. Number 3 element is the attitude of other countries, other claimant states. Are there other claimant states, and do they agree or not? This, the third one, is the most important one. The other states, because when we talk about a state's entitlement, claiming entitlement, sovereignty over a territory, the other state object. Doctrine of acquiescence in international, very important. Doctrine of acquiescence, whether the other state do not agree or agree. If the other states are not agreeing, they're always protesting, objecting. Right? This protestation, objections can affect the claim of sovereignty. This is a basic principle of international law. So that's the third element required, whether there is any acquiescence of other states. Acquiescence of others. Other states silently keep quiet and silent, or are they objecting or protesting? So these are the points. So now let us look at the 9th line claim, especially even the first and second ones, China could not prove clearly their sovereignty, exercise sovereignty over this, all the 9th line, all the 90% of the South China Sea. And then the third requirements of whether other claimant states are acquiesced or not. They are keeping quiet or not. We cannot say that all states are quiet, and that is doctrine of acquiescence. The element of acquiescence is missing. So there have been numerous consistent objections, counterclaims, and contrary state practice on the part of other states, and they solidly negate the elements of acquiescence. So let us look at the state practice law. State practice is very important for this, historical title, claim of historical title. Let us look at the state practice in respect of the rival claim. Are there any rival claims only China is claiming, or are there any rival claims? The most important rival claim was found even in the 19th century, 1884, 1885. Both China and France had competing claims over the South China Sea islands since Sino-French War in 1884-1885. That's why not only China, France was also claiming over the South China Sea islands. And France wanted these islands to be part of French Indochina. And China raised objection. That's why there was a war between China and France. So nevertheless, in 1933, France was in the upper hand. So that's why in 1933, France pronounced the annexation, official annexation of the Paracels Islands and Spratleys Island, and formally formally incorporated these islands into French Indochina. This is as far as France is concerned. Now, in the beginning of the Second World War, Japan seized all these islands from France. Japan seized and occupied all these islands from France. And after, when the Second World War over, there was a peace treaty with Japan, with other interested states at the San Francisco. We call San Francisco Peace Conference in 1951. In San Francisco Peace Conference, both China and Vietnam, now Vietnam. So why Vietnam? So Vietnam argued that they are successor of France. So they are colonial ruler. They are successor of France and they are claiming under the principle of jus possidetis juris. And both China and Vietnam, on behalf of France, they asserted their rights to South China Sea islands. And later, the Philippines also claimed to some of the islands of South China Sea. This is very early, then after Second World War. After Second World War. And later on, more recently, as you all know, Malaysia and Vietnam submitted their extension of the continental shelf beyond 200 nautical miles EEZ. China objected, and China claimed on the basis of 9-dash line in 2009. This China claim of 9-dash line in 2009, Malaysia and Vietnam immediately objected. So now in international, this objection is very important. That's why when there is objection, there is protest, there is no doctrine of acquiescence. And then after that, after Malaysia and Vietnam objected, Indonesia and the Philippines also raised their objection. So that's why it is very clear that there is no acquiescence on the part of the interested over the 9-dash line claim. And the requirements, the elements of the historic titles are not fulfilled. Okay. And then there are also some physical occupation of the maritime features in the South China Sea. The 5 claimant states occupy nearly 70 disputed islands, reefs and islets. Island means very small, tiny islands spread across the South China Sea. Vietnam, for example, currently occupies 21 features in the Spratly Islands. Philippines occupy either 9 or 10 features. Aba, the largest island in the Spratly, is occupied by Taiwan. And even Malaysia has occupies some of the five maritime features. Okay, and Brunei claims Luisa Reef. So that is why it means that now currently there are states, claimant states, which have occupied the maritime features in the South China Sea. This is contrary to what China is claiming over the 9-dash line. It is outdoing, negating the claim of 9-dash line. So thank you very much.
So, Professor, you're mentioning about the so-called historic claim by China. I think I have some very, I need to understand a few things here. I think I have some confusion regarding these topics. So, for example, Malaysia, we have a very close case to us, a very controversial one, which regarding to Pulau Batu Putih. And this case was brought to ICJ, and then ICJ ruling towards Singapore due to their claim of historic right. So based on your explanation, I understand that right to certain historic right to certain islands or certain places is only applicable if only one country claim it. So if multiple country claim the same, so what will be happen is the claim is invalid, something like that. So my question is, why in the Pulau Batu Putih case we are lost to Singapore based on the historic right, and why the Spratly Island China cannot do so?
Okay, that's why you are now equating the two not so relevant. Okay, not so relevant. situations or not too relevant cases or disputes, Pulau Batu Putih case and this South China Sea dispute. So South China Sea dispute is mainly China is claiming on the titles and on the seas, maritime areas, the South China Sea. Within this map, all the sea areas are theirs. So these sea areas also include small islands and atolls and something like that, right? They are not claiming on each and every sovereignty over each and every island, but they are overall they claim on this historic rights or historic right is not on land territory or islands. Historic right is only meant for waters, maritime waters. So that's why it's called historic waters. These waters are where Chinese naval vessels pass through and control and patrol around these waters. That's why all these waters are owned by China. That is the historic waters or historic titles over the sea areas, not the land territory or not the islands. So that's why we cannot equate the two together. Okay. So, and then Pulau Batu Putih is not historic title. There's no such thing as historic titles in Pulau Batu Putih case. Okay. So Pulau Batu Putih case is actually, so the Malaysia owned the island is owned by Sultan of Johor. So ICJ decided in this case, originally Pulau Batu Putih owned by Sultan of Johor. But in 1847, the Malaysian government, the British government at the time, the Sultan of Johor allows the British government to establish the Horseback Lighthouse there, and then to control the lighthouse. And after that, Singapore is not controlling the lighthouse; they are controlling the whole island, and then they're exercising sovereign activities over the island for many years, since 1847. When the dispute arose, 1979, when the Malaysia published a map in 1979. So that in the map, Malaysia put Batu Putih as under the Malaysian sovereign, within the Malaysian waters. But Singapore immediately objected. No, Batu Putih is not Malaysian. They own Batu Putih. So then this arose in 1979. And after negotiations failed, both parties agreed to submit to the ICJ. So before the ICJ decided that originally Batu Putih was owned by Sultan of Johor. But after that, after the lighthouse has been allowed to establish there, then Singapore was exercising sovereign activities over the island for so many years, and there was no protest at all from Malaysian side. Even when Malaysian officials want to go and visit the island or want to do some service around the waters around the island, they have to seek permission from the Singaporean government. So that's why this is mainly we call in French term the effective exercise of sovereign activities over the island. And then in the absence of any protest on the part of Malaysia, finally the ICJ decided that now sovereign has been changed from Malaysia to Singapore. So it has nothing to do with historic rights. And as I told you before, historic rights are historic titles to waters only, sea water, not to the island like Batu Putih is. Okay, thank you very much.
Okay, thank you so much, Professor, for the explanation. I'm sorry for my lack of knowledge in this situation, but I think you explained it very well, and I think I'm quite understand all the whole situation right now. So I think we can move to the next section where it's more spicy. So we're going to look into the security section, which is in the maritime security and the freedom of navigation. So now China has claimed this region. So what are the potential implications of the South China Sea dispute on maritime security and the freedom of navigation in this region? And how do they relate to international law?
Okay, so this one is also yes, very contentious issue, very contentious and very sensitive issue. So that is why this is something like melting pot, right? So the South China we can see as a melting pot because we cannot settle until now, right? After the event, the arbitration tribunal decided China didn't agree and China totally rejected the arbitration tribunal decision of South China Sea. And also although we have the declaration on the conduct of the states around the areas, China and ASEAN, declaration on conduct of activities, also not just to maintain status quo. But nobody is now maintaining status quo. China is also doing some military exercises and also some event. Some say that they are doing military bases in some of the atolls and islands in South China Sea. So that's why the security is in a very serious situation. So that's why unless and until we settle the sovereignty issue, the sovereignty issue is sovereignty of these are the islands and atolls and some of the maritime features which own which. So then the security problem can also not be settled, resolved. So that's why the first thing we have to resolve is the sovereignty issue. Okay, not the maritime areas. Maritime areas, it's very clear that China has no title, no historic title. But still unsettled is all the maritime features in the South China Sea. As I told you, China also occupied a lot, Vietnam occupied some, Philippines occupied, even Malaysia occupied some of the maritime features in South China Sea. So those who have occupied, they believe that this is theirs. They may have some military presence or police presence there for the purpose of administration, right? So that is why until now there can be no solution, because as I told you before, from international point of view, we have to settle the sovereign issue first. The sovereign issues, the UNCLOS. There's no way for UNCLOS to settle the sovereignty issue. Why? Because UNCLOS is only talking about the rights only. Maritime entitlement means what are the rights and duties of the states, like coastal states over these areas. Okay, so the sovereign issue can be settled only by applying general international law. That general international is international relating to the law of occupation. So the law of occupation is, you know very well about this. A state may claim, if the title is Tara Nalayas means nobody owns the title, the island, then who can get sovereignty over the island? A state which can exercise effective occupation over the island, effective occupation of the island. So to be effective occupation of the island, there must be intention to act as a sovereign. And number two is occupation must be effective in the sense that it has exercised sovereign activities to prove that the state is exercising sovereign activities over the island. So that is why many states are now, why they are establishing even airstrips, airfields, and then what they call helipads, and sometimes they are wharfs, jetties on the small islands, and some even bases, some even the facilities, some military facilities, some are not military but scientific and other facilities, telecommunication facilities over the island, showing that they are exercising sovereign activities. Now they are showing. China is also showing, and some other claimants are also showing on the islands they occupied. Okay, so that's why still there is a problem. Why? Because legally we cannot say that who owns which maritime features. So that's why I think my answer is that it will be an ongoing, the security issue will be an ongoing issue, and we have to have a patience and do not extend so much of the military activities over the island, and we have to reduce the military, exercises around the South China Sea. That is the only way, okay, for the security issues. Thank you very much.
Okay, thank you, Prof. So there is some cases that we can see China China naval exercising military exercise in South China Sea. So my question is, how do military activities and the use of force by different parties in the South China Sea impact the legal right and responsibility of the states under international law?
Because as I told you, international law doesn't allow a state which has no sovereignty over the area can do exercise military activity. Only within our own territorial sea we can do that. Even EEZ, exclusive economic zone, is very controversial for a state to do military exercise. But within the territorial sea, because within the territorial sea, a state can have full sovereignty. But exclusive economic zone, 200 nautical miles, not full sovereignty. Only sovereign rights for fishing, and then jurisdiction for scientific research, artificial intelligence. No military exercise can be done. But China can prove that this is within 12 nautical miles sea of the maritime feature, which they prove that they have sovereignty. Then only, this is from international point of view, then only they can do military exercises within the 12 nautical miles sea of the so-called their island owned by them, exercise sovereignty by them. Okay. Now sovereignty is not yet established, not yet sure that whatever China is doing is not in accordance with international law. Okay. But the problem is, as you all know, geopolitics, right? The problem is geopolitics, and the international law also, international law is intertwined with international politics, and international politics also power politics. That's why powerful states are, both China and America are competing here, right, in the South China Sea. So that's why China is a powerful state. So that's why even though China is doing that, we can just protest only, but can we do anything against China? Can we send our naval vessel to have confrontation with the Chinese naval vessel? I don't think so, right? We cannot do that. So that's why we have to be tactically, okay, diplomatically, we have to do that, because there is another big power is there. So if America is doing that, it's okay. But we, like Malaysia or Singapore or Brunei or Philippines, cannot do that. Okay, so that is why. So from international point of view, China cannot do that. But since China is a big power, she may be something like bullying. But anyway, we cannot confront it with our own military force, but we have to be tactical and use diplomatic means. Thank you.
Okay, thank you. Professor, based on the principle of freedom of navigation and the law of the sea, what measures can be taken to ensure the preservation of freedom of navigation in accordance with international law while addressing the security concern in the South China Sea?
Okay, freedom of navigation is, we have to first establish that, for example, this island, for example, is one of the Straddleys Island, is owned by China, right? China. Then, if owned by China, it's established that China owned that island, and it's like something about that island. Then, 12 nautical miles around the island is within the China's sovereignty. Okay, so that is why there is no freedom of navigation. You have only right of innocent passage only. If within the 12 nautical miles sea of an island owned by another state, other states have only right of innocent passage only. But in the EEZ 200 nautical miles, beyond 12 nautical miles, up to 200 nautical miles exclusive economic zone, then other states can claim freedom of navigation, but subject to certain laws of the coastal state, laws and regulations of the coastal state relating to fishing or scientific research or easy rights. But there are certain freedom of navigation. But high seas, if there are some high seas area which is beyond 200 nautical miles, is the exclusive economic zone of any of the islands owned by states, then there is high seas. But as I told you before, since we have not yet settled the sovereignty issue over the maritime features in the South China Sea, how can we definitely see that which area is high seas area, which area is exclusive economic zone of a particular country? Very difficult to say. So that's why still there is a dispute. Okay, only when we can establish definitely that these areas are high seas area, then that high sea areas, all states have freedom of navigation. Okay, thank you.
Okay, thank you so much, Professor. I think now we can move to the impacts of this dispute. Uh, to be more specific about the regional and the global impact. So the question is, what are the geopolitical implications of the South China Sea dispute on the country, in the region, and beyond, and how they impact international relations among those countries?
Okay, so China Sea dispute is, as I this is related to the reasons why the South China Sea dispute is so important, so crucial to be able to resolve, right? So because of that, that's why this is the impact is for all countries, not only for the regional countries. So it's directly related to regional countries, all the China, Taiwan, okay, Vietnam, and then Malaysia, Singapore, Indonesia, Brunei, the Philippines, all these countries, the natural resources. Now for Philippines, for example, for Malaysia, for example, so China is claiming up to the 9-dash line. That 9-dash is intruding the convention of exclusive economic zone of Malaysia. It is also intruding over the exclusive economic zone of Philippines and also Brunei. Brunei, for example, Brunei allows some international companies to do oil drilling over its own exclusive economic zone, but China says that you cannot do that. This is our 9-dash line. Within our 9-dash line, you have no right to do that. So that's there can be problem. That is why, unless and until we settle the sovereignty issues and then the resolution of the stable to become stable, all these disputes, we will have this problem in the near future. Still, we have so many problems regarding the natural resources, regarding fishing, regarding transportation. That's freedom of the seas, whether states can freely pass through or not. Freedom of navigation problem, security problem we have, and then because of the even though we have a very good relation with China, Philippines also, you can see Philippines is very tactical. Malaysia is also tactical. The Prime Minister visited China now, and we have a lot of investment from China, around 160 billion, right? So the good relationship there. So that's why even though China is as a big country, they are claiming more, and then they are sometimes a little bit like bullying some other countries, but we have to be tactful, and then because the geopolitics is there. So America also involved in the geopolitics. America don't want China to monopolize like South China Sea, but they are competing in many other areas, more important areas like Taiwan issue and now Ukraine issue, Russian invasion of Ukraine. So the geopolitics will be more widespread, more serious in future because of the rivalry between the two very big powerful states like China and America, and now Russia is also involving in that. So that is why, so for all these reasons, transportation, security, natural resources, economy, national economy, all these are affected. Not only within the region, ASEAN and other Southeast Asian countries, but also for the world power like China, America, and Russia, and even Australia is also very interested in that. Thank you very much.
So when we talk about international relation, what come to mind is the economic and also the diplomatic section. The question is, how do economic interests and diplomatic effort of countries involved in the dispute influence the legal dynamic of the South China Sea dispute?
Okay, so I think the legal dynamic cannot be changed because the law is there. The law is there. Okay, but this so long as the states themselves they must have the political will to settle all these disputes. I mean, in good faith, honestly, in good faith. So otherwise, then only we can settle this in accordance with international law. Legal dynamic cannot be affected because legal dynamic law is there, international law is there. The thing is that states, most of the countries in the South China Sea, they are not strictly following international law. Some states, they totally reject international law. Some states, they want to bend the law. Okay, they want to bypass the law, something like that. So that is the problem. Okay, so for international law perspective, international law is clear and the principles are there, but the application of these principles, because of the power politics and the will of states and the diplomatic relations between states, it may affect the application of the law. The application of the law will be quite, challenging because of these factors. Okay, thank you.
Thank you so much, Professor. I think when we talk about regional and global impact, we also have to include Malaysian role in this case. So I think we can move to the next topics, which is under the topic of Malaysia and the South China Sea dispute. So the first question is, how does Malaysia's claims and action in the South China Sea align with the legal obligation under UNCLOS and other relevant international law? And what are the implications of Malaysia's stance and on overall resolution of the dispute?
Okay, thank you. Okay, so we have our own laws, national laws, right? So national laws, we have to understand that we have laws, and these laws are also based on UNCLOS, on the basis of UNCLOS. That's why when the most important law for Malaysia is the Exclusive Economic Zone Act. Exclusive Economic Zone Act 1984. Okay. So this law is adopted after the UNCLOS, after Malaysia signed the UNCLOS in 1982. Malaysia signed the UNCLOS in 1982, and immediately after that, Malaysia passed a new law known as Exclusive Economic Zone Act 1984. Okay. In that law, Section 2 of the EEZ Act, we use the term Malaysian fishery water. Well, EEZ is mainly related to fisheries, fishing rights. So Malaysian fishery waters. So what is meant by Malaysian fishery waters means all waters comprising the internal waters, the territorial sea, and the exclusive economic zone of Malaysia, in which Malaysia exercises sovereign and exclusive rights over fisheries. So in the EEZ, we have only sovereign rights, so not sovereignty. Only in the territorial sea, we have sovereignty. But in the EEZ, exclusive economic zone, we have sovereign rights over fisheries and some other right jurisdiction over scientific research, environmental protection, and then establishment of artificial islands. Now, Section 3 says EEZ of Malaysia extends to a distance of 200 nautical miles from the baseline. So that's why Malaysia has the right to claim up to 200 nautical miles to the end of the EEZ, and Malaysia have sovereign rights over fisheries and other jurisdiction over the wild installations, artificial islands, and installation and devices. So, okay, so this is the EEZ Act. So that is why, so long as the area is within the EEZ, Malaysia can claim all these rights. Now, another one is Malaysian law is Contentious Act 1966. Originally, it was before UNCLOS. That's why it was a bit outdated. But in 2009, it was comprehensively amended in 2009. So now according to this Contentious Act Section 2, Contentious Act is up to the 200 nautical miles from the baseline is the minimum scope of Malaysian continental shelf. But in 2009, Malaysia added one new subsection, section 2A. So section 2A, the continental margin extends beyond 200 nautical. If Malaysian natural continental shelf goes beyond 200 nautical miles from the baseline, then outer edge means the maximum limit of the Malaysian continental shelf shall extend right up to 350 miles from the baseline, or even it can go beyond that. So this is the new section 2A added in 2009 before Malaysia submitted to the Commission on Limits of the Continental Shelf. Because of this statute law, our own domestic law, we claim that we can claim more than 200 nautical miles continental shelf up to 350 nautical miles. And China opposed to that. Okay, so this is the way. This is our own laws. What is our own laws? Because our own laws, we have the right to exploit and explore the seabed and subsoil. We have the right to fish and other rights within the 200 nautical miles. Okay. Now, another thing is the occupation of some of the maritime features in the South China Sea. So that one is I have no, because these some are confidential because I have no specific data on that. But if it is Malaysia can prove that they are originally owned by Malaysia from the so many years, like Sultan of Johor owned Pulau Batu Putih. So these maritime features are owned by Malaysia, then we can occupy these. And we can prove that they are our islands, they are our maritime features, and we can claim from their feature. If they are islands, we can claim, easy and condition from these islands. But if we cannot prove that, then we are also like China. We are also like China. We are claiming, we are occupying something which is not yet ours. But what we can do is that in these maritime features, we can show our sovereign activities, but naturally, not artificially. Okay. So thank you very much.
Thank you so much for a very deep explanation. So recently, we all know that Prime Minister had released press release where it's addressing this issue. To summarize it, basically, we Malaysia are against the China's claim over our territory, but we are open for negotiation. So the question is, how does Malaysia balance its economic and diplomatic relation with countries involving the South China Sea dispute while upholding its legal right and responsibility under international law? Maybe you can also explain what are actually our Prime Minister wanted to say, what are the details that maybe can be discussed here.
Okay, so this is whatever the Prime Minister says, this is the Malaysian policy, Malaysian stand. But sometimes also it is something like it can also be political rhetoric, because as you all know, I have already explained to you earlier that Malaysia has a good relation with China. Okay, China. So that is why, as far as we can stand, we stand. We will stand that this is ours. You cannot intrude upon that. Even though you are a big country, you cannot intrude upon that. We can stand that one. So, but we have to also, from international point of view, we have to prove that these features, maritime features, are ours. Okay, ours. Okay. If they are ours, then we can have strong stand against China, that China cannot intrude over these one. And then the best way is negotiation, bilateral negotiation. China doesn't want any third-party solution, third-party resolution, like the Philippines and China Arbitral Tribunal. China totally ignore that one. They don't like a third party, even a court or arbitration, to decide this dispute. So that is why the best thing is negotiation. So that's why Malaysia has to negotiate with China bilateral. Okay, bilateral. Since the two countries have good relation, then let for example Malaysia maintain our own claim, right? Whatever within features we are now occupying. Okay, this is ours, so we can claim our rights, maritime rights from these maritime features, and we will not also disturb whatever China has already occupied and claimed. So this is what they call a compromise. So the compromise and negotiation would be, I think, for the time being, the only solution to settle this. Okay, thank you.
Thank you so much, Doctor. So now we go to Malaysia's role. Malaysia's role in this dispute. What role can Malaysia play in promoting peaceful and lawful resolution of South China Sea dispute, and what legal avenues can Malaysia explore to protect its interests and contribute to the region's stability?
So that one is I have already explained to you earlier, just now, because we cannot go to court, not like Singapore. With Singapore, with Indonesia, we went to ICJ, right? For the dispute over the islands, we went to ICJ because the two countries agree. So to go to ICJ or even to go to arbitration, consent of both parties is required. But with China, with Brunei, okay, we can settle. We have already settled with Brunei, and we have also delimitation done. We have also there are some agreements. We have even the exchange of notes with Brunei, how to do this exploration of the natural resources of the sea areas. We have already done with Brunei. Okay, so but with China will not accept any third party agreement. They will not agree. So that is why the only thing is that negotiation. Okay, negotiation to peacefully to settle. We cannot use force. Okay? Peaceful settlement by means of negotiation. Even mediation, China will not accept. Let alone arbitration and go to court. Okay, this is my view. Thank you.
Thank you so much. I think that's a very good point. What can I understand is that we play the role to more go into alternate dispute resolution rather than going to court. So basically, you're more dealing with negotiation and mediation, something like that. So I think we can see the role of Malaysia plays in these disputes. Now let's look into the potential solution. This is more like professor opinions regarding this situation. So the first questions is what are the legal, diplomatics, and peaceful solutions that can be pursued to resolve the South China disputes in accordance with international law?
Okay, this is repeating again. Okay, so because I've already explained this one, so this is the conclusion of what? Or you have anything to discuss? Any questions?
I think we can move to the next question. I
Otherwise,
just
there will
want
be
to
repetition after repetition.
next question. Yeah, yeah.
Okay.
So the next question is how can international arbitration, negotiation, and settlement mechanism be utilized addressing legal complexity of this dispute?
I have already explained to you that point, right? Okay.
So I think we already covered most of the part from the potential solution. So basically, the potential solution is not go to the court, but go to the alternate
Yes.
dispute resolution instead. So I think maybe you can summarize a little bit, and maybe we can move to the Q&A section after that.
Okay. Thank you. What happened? I think we didn't hear you.
Hello, Prof.
Yes,
Am I audible?
I can. Yeah, We just lost contact from you.
Okay, I think. So maybe you can just summarize a little bit what have been discussed for today's discussion, and maybe we can move to the Q&A session from the audience.
Okay. Okay. So this is a quite. I mean, the South China Sea, as I told you before, is a very complex and complicated issue to resolve. Right. So then one possible option is to reach a compromise solution. So we have each and every state. We have our own claims. Malaysia has our own claim. Philippines its own claim, right? So currently, also they are occupying some of the maritime features in the South China Sea. So that's why. How about, for example, if Malaysia has occupied, for example, 5 maritime features. We keep that one, and we also recognize Philippines, for example. Philippines occupy 9 or 10 of the maritime features. We also recognize their occupations, and what China occupied, we recognize them. Between us only, before talking with China, between our small country first, okay, Malaysia, Brunei, Philippines, Vietnam, Taiwan, we discuss ourselves, and then we acknowledge the reality. Then we will recognize our own current status of occupying of the maritime features, and then we maintain ourselves and also recognize other states' occupation. Then it will settle among us first. Okay, so we get the understanding among us first. Then only we negotiate with China. Okay, China. Okay, we also recognize China's part, okay, properly, and then we say that this is our agreement. We have like this. We have this. So no state will go back. No state has to withdraw from their own current status quo. Then it can be one of the options. Okay, and then another point is we have only ASEAN and China. We have only DOC. DOC means Declaration of Conduct of Parties. 2002 we adopted 2002 Declaration of Conduct of Parties that no states all states should have self-restraint in the conduct of activities, and no state should escalate the dispute and should extend unnecessarily the small islands to become big islands, right? So we have to maintain status quo. That is in accordance with Declaration of the Conduct of Parties in South China Sea, DOC 2002. But there are consultations to develop this DOC into Code of Conduct, COC, Code of Conduct in the South China Sea. Then Code of Conduct will be there, will a little bit more bindingness. China and all the participants, including all the ASEAN member countries, we can strengthen the DOC to become Code of Conduct, COC, in the South China Sea. Okay, and then so this is negotiation part. Among ourselves, we negotiate first, and then the small country together negotiate with China. Then we have to develop the Code of Conduct in the South China Sea. But as I told you before, for me, so I don't think that going to court or arbitration can settle this South China Sea dispute. Okay, thank you very much.
Okay, thank you so much. I think that's covered almost all part of it from this international perspective of the topic, South China Sea dispute. So, ladies and gentlemen, our beloved audience, please free to comments in comment section. Either Facebook or YouTube is fine. We will read it to you, and then maybe you can hear Professor to answer it. So maybe, Prof, we can give a little bit time for our audience.
Okay, no problem.
Maybe we can continue in 11:58, something like that. Is it okay?
Oh, now 11. Now is even almost 12 o'clock now. Oh, we have done 2 hours, Mr. Faris.
Yeah.
2 hours now. So I think we should not have a break. Then let them do some Q&A, and then let us end the section because it's too long now. So the audience will be very tiring. I am also very tiring now. 2 hours, you see, not 1 hour.
Okay,
12
we
o'clock
will,
now, 12, nearly 12, 5 to 12.
I'll be sure to keep
Mhm.
my eyes open.
so we will take a break for a while, and in the meantime, you guys can send your questions. I can see there is a lot of questions coming in the chat box.
The question they are put in the chat box.
It's okay. We will, uh, because I think you cannot see the questions, but we will put it in the screen later. We will pick. It will appear on the screen. I will read it to you. But
Okay,
right
thanks.
now, I can see the whole comment section. This is only available for the technical team. Okay, Bismillahirrahmanirrahim. Assalamualaikum. Welcome back, everyone. So currently we are moving to the Q&A session. I can see there is a lot of comments coming in. There is 13 or 15, something like that question. I know it's very, our audience is very high for it. So I'm afraid uh, we cannot address all of your question because some of the questions are repeated. I will already be answered, and because we are also lacking of time right now, so I think we are going to look maybe around 5 questions, something like that. But I will ask my committee. Maybe they can ask the question, uh, reply the question in the chat box. So moving on to the first question, I think there is some very interesting question from Bona Fide. I'm not sure if that the correct way to pronounce your name. So question from Bona is coming from our YouTube channel. I want to ask, and hopefully it will be answered later, but with the rising tension between China and Taiwan, as well as China aggressions policy in the South China Sea, such as conducting naval operation, Hans, in rough opinions, do you think it will be affect Malaysia policy towards South China Sea dispute with China? And if so, how should Malaysia approach the issue with China?
Thank you for the question. But I have already, I think, discussed in the earlier my discussion earlier. So yes, there's a now very high sensitive issue between China and Taiwan. It's a very sensitive issue. But this is not affecting so much towards Malaysia, because Malaysia is a peaceful country, right? Malaysia is a peaceful country, and with Malaysia, there is a very good relation with China. Okay, so that is why, and then I don't think it may that the Taiwan issue may escalate to become a world war, because American see that it will always protect Taiwan. But I think the two big countries will not go to the extent that they go to war because of the Taiwan problem. So for us, it is not directly affecting Malaysia in any way. Okay, so for us, we will be peacefully dealing with China, and then as I told you before, China is a big power, and we have good relation with China. We can proceed with this good relation with China, and it will not affect anything. So now we have good response from Chinese investment, nearly around 160 billion to Malaysia. It will help Malaysian economy a lot after this COVID-19 situation. Okay? So I don't think this will affect Malaysian position. Thank you.
Okay, thank you for your answer, Professor. There is one more interesting question coming from Nurin from our official Facebook. The question is, how can the rights and interests of smaller or less powerful states in the South China Sea be protected under international law? And what more can be done to ensure that their voice are heard?
Okay, so international law is there, as I told you before. International law is there, and there are international principles. But states sometimes, if their national interests are at stake, they are not complying with international law. They want to bend the law. Now, this is what is happening in South China Sea, right? They want to bend the law, or they want to just bypass the law to their own national interest. So, and then if that country is like a small country like Brunei or Philippines, Malaysia can very easily negotiate with the country and settle easily. But it is a big country like China, so it's very difficult to settle this. Although international law is there, international law has some limitations, especially as I told you before, international law is based on international politics. International politics is power politics or geopolitics. Okay? So that is why there are so many problems we cannot settle by international law. Like, for example, now Ukraine problem, right? Russian invasion is a very clear violation of international law by Russia. So can we take action against Russia? Because Russia is one of the big five permanent members, one of the Security Council permanent member. Any enforcement of international law must come from United Nations Security Council. In the Security Council, there are big five. So they are 500 members and they have veto power. China is also one of the big five. It has veto power. So long as we talk about enforcement of international law, we cannot enforce international law against these big countries. That's why I always told in my discussion that we have to be very tactful and we have to try peacefully to negotiate with these big countries. Thank you very much.
Thank you so much, Prof. I think we can cover one more question. So the question is also from Bona5. So the question is, as the US increase its intervention in Southeast Asia, the likelihood of US intervention in the South China Sea increase, which could escalate tension with China. In Prof's opinion, how can ASEAN take measures to prevent the South China Sea dispute from escalating into conflict similar to the Russian-Ukraine conflict?
Okay, yes, it's also a good question. Yes, we have to be careful about this one because of the two superpowers. Two powerful states are now competing. So in the South China Sea area, especially China is a small stake at stake for China because their Belt and Road initiative also must come through the South China Sea, right? South China Sea. So that is why. So then American is involved, but I don't think American will be so. So rigorous to intervene in the South China Sea because it's quite far from, even though there are some states, but it's quite far from America. So that we don't need to scare too much about American intervention in the South China Sea. Even Taiwan case, American promised that they will protect Taiwan. But if China invade Taiwan, will there be a war between China and USA? This is the problem. So that's why sometimes some powerful states like America are doing some political rhetoric. So they are intervening, but they may not go to the extent that they will confront each other and there will be a war between the two countries. But they will doing political maneuvers only. So America will not use force in South China Sea because this is the China's area. The China interests are more at stake. So that's why they will not rigorously involve or intervene in the South China Sea. And that is my answer. Thank you.
Thank you so much, Professor. I think that's covered everything. So before we end our session, on behalf of our committee, I want to apologize for all other questions that we are unable to address it here because mostly the question can be answered if you look on our first few hours discussion. We already covered that topic. So basically, for the alternative, for the solution, is Prof suggesting that is we're not going to the court and more engaging in the alternate dispute resolution. So I hope that's covered everything. So thank you. Thank you so much for your wise answer, Professor Dr. Abdul Ghaffar Hamid. Due to the fact that we don't have much more time, we will wrap up this Q&A session here. Unfortunately, we have come to the end of our session. Thank you, sir, for willing to spend your time and energy sharing us your knowledge and experience. And we would like to express our gratitude to our esteemed panelists, Professor Dr. Abdul Ghaffar Hamid, for taking his time to join us today and provide his valuable perspective on this crucial topic. And we also like to thank our audience for the active participation and thought-provoking question during the forum. Your engagement has made this discussion truly enriching. As we conclude this session, of the ILSA UniSZA Forum Series number 1, 2023. We encourage everyone to continue exploring and learning about the South China Sea dispute and its international law implication. Staying informed about concerned legal is vital, and we hope that this forum has been a meaningful platform for knowledge sharing and understanding. Thank you once again to our panelists and audience for their participation. We are looking forward to hosting more insightful discussion in this future. That's right. Keep an eye on upcoming forum event from ILSA UniSZA. Thank you so much for joining us. Until then.